Appeal in the matter of McGaughey and another Universities Superannuation Scheme Limited and others.
Good morning. Mr. Grant, Mr. Shaw, the court sent an email yesterday because it appears to all three members of the court that this case has been proceeding on an entirely false basis. It's not in truth a corporate nonsense claim at all. It's a claim by a charity claim by beneficiaries to bring a claim against third parties, effectively directors of the trustee company, on behalf of the trust, pension fund. It's a pension fund that suffered a loss. And that principle is governed by, in one sense, not dissimilar principles, but not identical principles. And that's why we suggested that the parties might want to consider their position and address us on that issue at the outset.
Certainly. My Lord, may I begin as I was going to begin and then deal with that point as soon as I am able to. Now, I'm here with Mr. Steer for the claimants, appellants. I shall call them the claimants. Until recently, I was instructed by the Public Access Scheme, but Lee Day are now on the record. The two claimants, Dr. Ewan McGaughey and Professor Neil Davies, are in court and sit diagonally behind me. The first defendant respondent, USSL, are represented as they were below by my learned friends Mr. Short, Ms. Pugh and CMS Cameron McKenna. This, as your lordships appreciate, is an appeal from a composite order of Mr. Justice Leech made on the 10th of August of last year, in which he refused the claimant's permission to bring claim as a multi-derivative claim on behalf of the company. The application was made by analogy with what was then CPR 19.9 and is now CPR 19.14. In terms of housekeeping, there are three substantive bundles. The core bundle, Supplemental Bundle 1, which contains the 5 relatively brief witness statements, Supplemental Bundle 2, which is the other documentation. Permission has been granted last week for the parties to rely upon a bundle in excess of 350 pages, which the parties are grateful. In terms of
time and again, we're invited to agree to supplementary bundles of more than 350 pages, and time again, we never look at very much. Well, there we are.
In this case, I suggest we will, my lord. Of course,
we've got composite bundle of authorities.
Yes.
Goodness knows how many of those, and also a core bundle of authorities.
Yes.
Which is helpful. Thank you.
Yes, in the core bundle of authorities, so the court is aware, contains the vast majority of the derivative claim. So certainly in the morning, when I propose to address the court on the legal background, the framework for the matter, dealing with the court's concern head on, I hope, and other matters, we will primarily, if not exclusively, be looking at that core bundle. Right. You have replacement skeletons within the core substantive bundle, a total of 3 skeletons, the appeal skeleton, the respondent skeleton, and my skeleton in reply. You also have, hopefully by email this morning, our written submissions on the point that was causing the court concern yesterday.
No, but I think it's been put on our bench.
No, well, I'll come to that.
We've got a transcript, haven't we, as well?
Yes, the transcribers are joining remotely.
Yes.
I can check, because I understand they will email everyone, including, I'm sure, the court's clerks at the end of the day in the normal way.
So does that mean that we do or do not have a break?
It's a very good question. I don't know what arrangements have been agreed or
Last week
sought.
we had a remote transcription service and we were invited to take 5 minutes. So it might be sensible to do that.
I'm happy to do that. It's clearly a matter for the court, but I suggest just before noon today, this morning may be appropriate. In terms of pre-reading, the party sent an agreed list of pre-reading last week on the 8th of June. It would be helpful, I'm sure, for all parties to know what the court has been able to read of that list. It's quite extensive.
All of it.
Is that a unanimous position, or simply from my lady?
Speaking for myself.
Yeah.
Well, all the parties are extremely grateful. That is very helpful. Indeed. The only other additional matters is the the 7 additional authorities handed up this morning and our submissions on the Robertson Gill point. If I can just explain what the 7 authorities are. The First one is part 3 of the Pensions Act 04. Some extracts are already in the composite bundle. Other parts are set out or paraphrased by the judge in his judgment, but we don't have a complete part. And while I'm sure familiar to my lady, maybe less familiar to the other members of the court, and it's useful to have. Part 2, again, just one regulation of the scheme funding regulations which was omitted. Part 3, Lewin, on a different point, the exercise of power, we are putting it in relation to the exercise of a power for an improper purpose argument. Fourth point is the Court of Appeal's decision in Robertson Gill, my learned friends have suggested. 5 and 6 are the 2 authorities which my Lord the Chancellor identified yesterday. And 7, that's the skeleton argument which I put before Ms Justice Leech at the ex parte hearing on the 28th of February last year. So not the judgment under appeal, but the hearing prior to that,
the first
in which, as we'll see, I had to engage with a pretty similar point to the one which the court is concerned with now in relation to Robertson Gill. And hopefully to expedite the process, we have indeed provided submissions on Robertson Gill this morning. That's a 6-7 page document which includes extracts from Authority 7, my skeleton of last year, plus some more context for the point we're making. And I'll come to that shortly.
Right.
In terms of timetabling and structure, the agreement between the parties is this, that I will spend today and potentially a little bit of tomorrow, my submissions, my learned friend will then follow, taking up the whole of tomorrow, spilling over a bit into Thursday, and I then have a reply. We understand on Thursday the court will sit at 10 o'clock until 12:30. We have a lot to get.
That's immutable, I'm afraid, because I have to go abroad.
No, I understand. We have a lot to get through, potentially, and we shall do our best to do so. And to the extent that I encroach today and tomorrow morning, that will then come off my reply. It's the agreement we've struck. As I've said before, this morning, I'm intending to set out the background to the matter as briefly as I can, and then deal with grounds A, B, and C, and the first part of the respondent's notice, which is the question of whether an alternative remedy is an automatic bar to a derivative claim. Quite early on in that, I will address the Robertson Gill point head on. The remainder of the respondent's notice is concerned with the alternative argument that an alternative claim may be a discretionary factor, and I will deal with that in my reply on Thursday. In terms of the background, this is covered by the judge in his judgment, paragraphs 3 and following, but very briefly, the company is the sole corporate trustee of the Universities Superannuation Scheme. It's a non-profit company, limited by guarantee. Under Article 71, which we'll come to in due course, it exists solely or primarily to act as the trustee of the USS pension scheme for the benefit of university teachers or comparable staff. USSL has no shareholders, and directors are automatically appointed as members thereof. That's Article 2 of the Articles. That means that USSL's normal organs of control, both the board and the general meeting, are entirely in the hands of the directors. The scheme was established in 1974. See that from paragraph 3 of the judgment. There was a predecessor scheme. It was formerly an exclusively defined benefit scheme. It's now a hybrid scheme, which means that members earn in part defined benefits and in part defined contribution benefits. It's a career average as opposed to final salary scheme for academic and comparable staff in universities and other higher education institutions. The scheme is one of, if not the largest, private pension schemes in the country, and has had in excess of between 65 and 90 billion pounds worth of assets through the course of the time period with which we are concerned. There are 343 employers, according to the judgment, and the total number of members as set out in paragraph 4 of the judgment is in excess of 480,000, and doubtless would have increased since. The claimants are
That figure includes pensioners and deferred pensioners.
Yes.
Sorry to interrupt you.
Not at all, my lady.
Thank you.
The paragraph 4 breaks down into 4 categories, including 1,000 odd child members, but it's an inclusive figure. The claimants are active members. Dr. McGaughey joined in 2008 and Professor Davies joined in 2006. In terms of the framework of my submissions this morning, I wish to outline or make the following points. First of all, that this is, properly speaking, a company derivative claim. Secondly, that there is no requirement.
Sorry, when you say it's a properly so-called a company derivative claim, I thought it was accepted by both parties that the procedure for company derivative claims does not apply.
Well, you're quite correct, my lord, but what I mean by that is to distinguish it from the Robertson-Gill paradigm of derivative claims. I say this is a claim in respect of which the claimants are seeking to claim on behalf of the company against directors.
So, is this right? All the damages or otherwise that you say will be recovered will be held by the company for its own purposes?
Yeah, so this is a claim on behalf of the company. No damages are sought in terms of relief. But nonetheless, your lordship's point is correct. This is a claim on behalf of the company against the directors.
So all the other, so if this were right, all the unsecured creditors of the company would have access to any recoveries that would be made in this type of claim. Is that right?
Well, query whether that would arise, but...
Okay, but if in concept this is a claim so I just wanted to get this right at the start.
Yeah.
If you're saying this is a claim on behalf of the company, do you say it's on behalf of the company as a corporate entity, and such that the damages, if there were damages recovered as a consequence, would be held for the company as a corporate entity and therefore available to pay its other external unsecured creditors? Or are you saying that these are damages which would be held by the company on trust for the beneficiaries of the trust?
Well, it's somewhere in between, because it's a corporate claim by the company against the directors. The company's purposes, as we see, are primarily or exclusively in relation to its being trustee of the scheme. The members of the company have no personal benefit, so the purposes are different to a classic company for profit, where the shareholders are the people for whom the purpose of the company exists.
Let's leave it there for now.
Yes.
I'm going to come back to it because if you've looked, I'm sure you have looked at, for example, Underhill, it highlights this very problem. So simply, as it were, calling it a company derivative claim is a label which is apt to confuse. And speaking for myself, I'd be much more enlightened if we tried to identify on whose behalf the claim is made and who would be the personal persons on whose behalf any recoveries would be made.
Well, I'll seek to deal with that in due course, my lord. So I was explaining the...
I'm so sorry, Mr. Grant. You also said, quite rightly, that actually damages are not sought.
No.
It's declarations and injunctive relief.
Yes.
And that might be something that's relevant later on, I think, in relation to what the very nature of this claim is and whether or not it is on behalf of the company. We'll come to that.
Certainly. So ground A is the claimants say there is no requirement of reflective loss for someone to be a suitable person to bring a derivative claim. One of the findings of the judge. Second point I wish to develop this morning is that the existence of an alternative remedy in the hands of a company is not a self-standing bar. That's the first part of the respondent's notice. We say that's all tied up with the concept of wrongdoer control.
Mr. Grant, would you just repeat that for me? The existence of a...
Alternative remedy
No.
in the hands of the company is not an automatic or self-standing bar.
Yeah.
to a derivative claim. That's the first part of the respondent's notice, relying on Public Bill Authority and Parry and Bartlett, amongst others.
Right, at the risk of going back just over the point, because you, in a sense we skipped off too quickly, although you're right that technically the relief you seek is a declaratory relief, I noticed that it is a declaration that the alleged breaches have caused or will cause the first defendant loss. So the question which I raise, I think, is squarely raised. You can't duck it by saying it's a declaration, not recoveries. Not least because you then ask for accounts and orders and inquiries and the like. So you've got to identify what you mean by the first defendant being caused loss. Are you saying it's caused loss in its capacity as a company, with all that that entails, or are you saying that it's loss qua trustee, in which case it's identifying loss to the trust fund and in reality therefore the beneficiaries?
I see the point. The next ground is ground B, which is what the test is of the exception to Foss and Harbottle. Is it furthering their ends, as we say, or is there a requirement of some financial benefit as the judge appeared to have held?
Well, I don't think the judge did hold that respect. I think this is a complete normal point. I think it's just a misreading of perhaps the judge expressed himself in a slightly oblique way. But if you read the judgment as a whole, it's perfectly obvious that he thought this Stamco was good law, and therefore, if you show some other benefit to the directors, other than the financial one, that may be sufficient to satisfy the test. And I think that is what the judge is saying. So I'm not sure that it is necessarily a real point in that respect.
I know what your lordship says, but nonetheless it still is pertinent to what the judge found and the consequential decisions he made in relation to grounds C for all four claims.
Yeah.
And finally, for this morning at least, the question of whether prima facie, what that really means in terms of the test.
C.
That is ground B. Sorry, that's ground C. I described the previous one, which is ground B, which is the furthering of their ends. So that's the structure I propose to adopt this morning. Before I come on to the Robertson-Gill point, if I can just set out by summarising the consequence of Foss and Harbottle, which we say is as follows. It is authority for three propositions. First, the proper claimant principle, by which the cause of action concerning a company vests in the company itself, which is ordinarily the proper claimant. That is what is typically described as the rule in Foss and Harbottle. In other words, it's not a matter of course for the individual members of a corporation to assume to themselves the right of suing in the name of that corporation. The second proposition, the second principle that emerges from Foss and Harbottle, is the majority rule principle, by which an individual shareholder will not be allowed to pursue proceedings if the matters complained about could be ratified by the majority in a general meeting. The third point is the interest of justice exception, whereby a strict application of the first two principles would lead to injustice. This claim and this appeal is principally concerned with the third proposition, in other words, the exception to the rule in Foss and Harbottle, especially when there is wrongdoer control. In my submission, the other propositions are relevant. Ultimately, the constitutional checks and balances between board and members mean that the courts have historically been loath to interfere in the running or administration of a company when there is an untainted majority. The autonomy of the company is also relevant and underscores the rule against reflective loss we see in cases such as Marex and Sakania. At its purest, the point is this: it's for the company to decide whether or not to bring a claim, whether to sue. And we see that point in a number of cases, particularly in the alternative remedy claim, and particularly in relation to ratification, where the courts have said, well, as long as there is the possibility that the membership in a general meeting can ratify or approve that decision, then it's fine. Equally, if there is an untainted majority, they can decide whether or not to bring the claim. the interest of justice exception is confirmed by a line of cases which shows that when the wrongdoers control the company, namely at board and member level, the court will permit claims by someone other than the company on its behalf in order to avoid the obvious injustice. That procedure is the derivative claim. In our skeleton, we refer to some of the cases which the judge mentioned in his judgment. They are well known. I can take the court to them if required. First of all, Lord Denning in Wallersteiner and Moyer. Secondly, Lord Justice Brown Wilkinson in Nurkham and Nurkham, principally a case about election, but also a case on derivative claims. Other case, MacDonald and Horn, not a derivative claim as such, but a pensions claim where the equitable concept imported into company law in Wallersteiner and Moyer was then imported back into trusts law by way of analogy of the position of pension scheme beneficiaries to members of a company. And other high-level cases which have dealt with the concept of injustice include the Hong Kong court in Waddington, which we'll consider later, and perhaps most recently, this level at least, Mr. Justice Briggs, as he then was, in Universal Project Management Limited in Fort Gill Kicker. Good. I'm happy to take the court to those authorities now for the propositions which I've just set out. They are brief references. We can hopefully do that very quickly, but it's important to set the context for much of the debate that's to follow. So first of all, Wallersteiner and Moyer, that is in the composite bundle, tab 24, which I think is volume 1. No, sorry, composite.
It's in the composite.
So composite bundle at, sorry.
Tab 24, my lady.
So it's composite 1.
Composite 1, tab 24.
Yeah.
It's page 236. And it's the passage highlighted in the red vertical line at the top. I can read it out or invite the court to read it themselves as you see fit.
Should we read that to ourselves then?
It's really just under B, but suppose it is defrauded by insiders who control its affairs.
Just picking up a point which we'll come to, what Lord Denning is saying there is that the remedy that the law allows is for somebody to be appointed to be the representative of the company to pursue the cause of action in the name of the company. So just following the thought process through, assume that the company succeeds when the claim is brought up by the representative. The damages will be the company's. In other words, it's not the representative doesn't get to trouser the proceeds. I mean, they're held by the company and therefore will benefit all the shareholders. The company is a corporate entity, so first of all unsecured creditors, for example, but then shareholders ultimately, on whose behalf ultimately the representative has been bringing the proceedings. Let's look at this instant case. You have two clients. Are they representatives of all the members of the pension fund equally and of the same interest in the way that shareholders are?
We are saying that they are appropriate people to bring the claim because there are no members independent from the board, there are no shareholders, isn't a subsidiary or a sub-subsidiary case.
I appreciate that's what you're saying,
So, yes.
say this, I will ask the question again, because I don't think your answer, with respect, was an answer to my question. Are your two clients, claimants, representative in the same way as a shareholder would be of the general body of shareholders, i.e. they have the same rights and interests of all the members of the pension fund?
I say ultimately yes, because in both cases, even in...
Where's the evidence of that? Because I thought, and you mentioned it at the start, that where the claim, a derivative claim, was not using the CPR procedure for corporate derivative claims properly so called, in paragraph 17, the judgment is accepted that this is not such a case, that you have to go through the representative claimant process, which is set out in what is now CPR 19.9, I think, to be properly appointed representative of those who Lord Denning would identify, namely all the beneficiaries of the pension fund in this kind of case. Why hasn't that been done?
Well, that's one of the points we raise in relation to an alternative claim. One of the points which the USL have raised throughout this litigation is why isn't this claim being brought as a breach of trust claim by beneficiaries against USSL as trustee? And one of the answers we have, and I was going to come to this in my reply.
But sorry,
Yes.
again, it's not answering the question. You're purporting to pursue the company's claim. You're not pursuing a claim which is currently vested in your own clients.
No.
And so you have to be appointed by law as the representative of somebody else, don't you?
No, because that begs the question. I said if we were bringing a direct claim as beneficiary in breach of trust, we would have to do that, and that's one of the reasons. I say you would have to go through the process, which we say is a complicated process of identifying the different classes and interested members.
I know that, that's why I'm asking
Exactly.
the question.
I know, but if we can just, first of all, I can just set out what would happen for a direct breach of trust claim, and then compare it to the process here, and why I say that the derivative claim process effectively absorbs some of those concerns, but is a different process. So in relation to the breach of trust claim, I think your Lord accepts what would need to be done. There would need to be representation orders under CPR 19.9. There would be, we say, much inquiry as to who the appropriate classes would be, whether they can sufficiently be represented by one or two classes of represented beneficiaries or whatever. All those are legitimate concerns, and some of the reasons we say as to why procedurally a direct breach of trust claim would be difficult, because one of the provisions of the CPR says that when an individual has a claim, which everyone else in that class also has, the starting point is that all those people with the same interest must be party to the claim, unless the court otherwise orders. I'm paraphrasing, but that's the thrust of it. So we say those are all very legitimate concerns for a breach of trust claim. Compare the position with the derivative claim, and let's start with the paradigm position of a company limited by shares. If one individual shows that he has sufficient interest, whether in being a member of the company or a corporate shareholder or the corporate shareholder's shareholder, etc., how many divisions one goes up, nonetheless, there's never been any question as to whether that person carries the agreement or carries the support of all the other members or shareholders. As long as there is evidence of wrongdoer control, as long as the company is tainted in that sense, then it's sufficient just for one individual as a member to say, I have an interest, I am being subjected to a fraud on the minority. Slight misnomer though that phrase is, and I am an appropriate person to bring this claim on behalf of the company.
And, Mr. Grant,
Yes.
I am somebody who has suffered loss, and this is something you'll come to,
Yes.
but the loss that I suffer is reflective of the company's loss or vice versa.
Yes.
And that helps to show that that person is the person with appropriate standing because they're suffering the same loss or
Yeah.
a proportionate amount of the same loss, and that's why they are in the shoes of the company. But if I think, and I'm sorry to jump in,
No, not
I
at all.
apologise both to you and to my Lord Justice Snowden, but that is why they are synonymous and the shareholder has standing. Here we're trying to winkle out what the position is when a member, or in this case two members, say that they fall within a derivative claim like this, when in essence they're, and you're going to tell me that I'm wrong about this, and I'm very eager to hear what you say, when their interest is not the same as necessarily, maybe not, in relation to other classes of member within the scheme whose loss, if there is any, let's assume there is, may be different or borne differently, and that's the issue that's troubling us.
Or we may not have suffered a loss at all. In the case of some of the other members of the scheme,
Yes, but
look at it in terms of the scheme members. There will be, there may be scheme members who will say, of the valuation issue, well, we're actually perfectly happy with that because our overall position is better protected now than it was previously. So different members of the scheme have different interests, and you, if I understand what you've summarised so far, you seek to avoid that issue of what you quite rightly describe as a difficulty of bringing a claim for breach of trust by saying, oh no, we can avoid all that by bringing a derivative claim of this kind. What my lady is putting to you, and certainly I will need about all this, is that all the claims, all the cases where this has arisen have really been, once the statute, leaving aside the scheme under the Companies Act, which is for as it were, the direct shareholder, minority shareholder claim. The so-called multiple or double derivative claims are all ones where the claimant is a shareholder in the subsidiary, for example, but there are also cases where the claimant has suffered a loss, which is reflective of the loss of the company.
yes, well, there's quite a lot in that, and I'll deal with the reflective loss bit later on. But perhaps if I can deal immediately with my lady's question, reflective loss. I say the fact that in the classic shareholder case, a shareholder has suffered reflective loss is a function of the very corporate structure. Because if a company run for profit, it then will follow that the shareholder will have suffered some loss, which is reflective of the company's loss. But that will undoubtedly be true in all profit cases where there are shareholders.
Yeah.
So having that as a requirement doesn't really add anything because it's going to be an inevitable feature of those cases. What we are concerned with here is a company limited by guarantee. This is, as far as our researchers have revealed, the first such case in which a derivative claim has been brought. Est Manco was a company limited by shares, albeit a not-for-profit company.
Right.
That's the closest example we have. There are different kinds of derivative claims. It might be helpful just to provide this threefold classification. Starting point is a statutory claim in relation to a Company Act registered company or incorporated company. That's a statutory claim under section 260, and CPR 19.14 applies directly. The next main category are claims by members of other body corporates, for example, trade unions or LLPs. Those are common law claims, so on one level at least multiple derivative claims, even if there is no concept of subsidiary. But CPR 19.14 applies directly. And I quote, the rule applies to a derivative claim where a company, other body corporate, or trade union is alleged to be entitled to claim a remedy, and a claim is made a member of it.
I mean, speaking for myself, I don't think it helps to call it a multiple derivative.
No,
claim. It's just a derivative claim.
It's a derivative
It's
claim.
the species, the first one, isn't it? I mean, it's not under section 260 as such, but it's the same concept.
It's the same concept, but the test that one has to show is an exception to the rule in Foss and Harbour. for one of the exceptions. And examples of that are Edwards and Halliwell, which is the trade union case, and Harrison Microfusion, which is a LLP case, where we're concerned with members of the LLP, but nonetheless they had to show an exception to Foss and Harbot. The third category is claims by people other than members. The classic case is the shareholder case, for the shareholder of a holding company, however many subsidiaries. In Fort Gilkicker, Miss Justice Briggs said that's typically what was called a double derivative claim, but whether it's double derivative or multi-derivative, it's a question of terminology. It's quite clear there's no limit to the number of intermediaries. And Waddington was a case where parallel derivative claims were sought to be brought, one on behalf of a subsidiary and one on behalf of a sub-subsidiary, which raises interesting points in reflective loss I'll come on to in due course. The ultimate owner may be an LLP in Fort Gilkicker, or may be a trust, as in Popley and Popley, which we'll come to shortly. But that's just simply a quirk of the facts. The variation here is in a company limited by guarantee, there is no verticality of ownership. If, well, let me start this again. A statutory claim could be brought by a member of USSL. We say that won't happen for reasons which I hope are obvious from the written submissions. Professor Hutton, whom you may have picked up in Skeletons, a former director of USSL, since dismissed, she was able to bring a claim even though she was only one of 15 directors, apparently of her view. So in answer to the question raised by the court, one wouldn't have to show that her stance was reflective, to use that word slightly out of context, of those of the other members.
Mr. Grant, I haven't picked up on this.
No.
Please explain.
Well, so
Professor,
Professor Hutton,
yes.
she was a former director of USSL. Her name is mentioned, we'll come into it both in Claim 1 and potentially Claim 4, but perhaps that's going to complicate things at this stage. For example, imagine a member of, a director of USSL would be entitled to bring a statutory claim under Section 260. Even if they were the only director who felt that a claim was being overlooked or that a claim should be brought.
In fact, technically, they wouldn't be quite entitled to bring a claim. What they would be entitled to do is to apply through the Companies Act process for permission to bring a claim.
Sorry, I'm using that as a shorthand, yes. They would be, but they would come within the procedural, so they would come within the statutory framework of Section 260. Your Lordship's quite correct.
But they'd have to go through
Of course, I'm
the
sorry.
process.
If your Lordship inferred I was seeking to suggest they could bypass the permission route,
No, no.
that wasn't my intention.
They would have to demonstrate that by ticking all the boxes and satisfying the various statutory codification, if you will, of
Yes.
the previous law, that they were an appropriate person to bring a claim on behalf of somebody else,
Yes.
namely the company. In other words, pursuing
Yes.
a claim vested in somebody else. And if they did, the damages would be recoverable by
Yes.
the person on behalf of
Yes,
the corporate entity.
indeed. That's exactly how the derivative claim works. So a claimant is bringing a claim in place of the person in whom the cause of action is vested as their representative, as it were, but on their behalf. Now, perhaps that is the appropriate point to deal with the Robertson-Gill point. If I can refer the court.
Before you do that,
Yes.
Mr. Grant, I'm just trying to
Yes, certainly.
process all of that, and I apologise for holding you
Not at all.
up because I know we've got a lot to get through. But we're still then in the position that we were a little earlier of how, when we're outside Section 260 and we're in a situation in which we have a company limited by guarantee, can we satisfy ourselves that Mr. A and Mr. B are appropriate persons to bring an action on behalf of the company, and that their interest coincides, if you see what I mean, and that they are the right people. And I don't think that you've quite got to that point yet. But I think that what you are saying, that purely being a member in these circumstances means that they do have standing and that they don't have to worry themselves about any of the complications and difficulties which would arise if this was a direct claim against the company for breach of trust.
Yes.
Is that it in a
Yes,
nutshell?
that's the statutory paradigm. Imagine, let's call it the hypothetical member of USSL, a director who seeks to bring a claim, seeks permission pursuant to section 260. They would clearly have to satisfy statutory framework as set out in section 260 and following, and the procedural framework in CPR 19.9 applying directly. But they would not have to show, agreeing with your lady's last point, any particular reason as to why their position is also embraced by other people, other members of the company. It is enough
Their
for
status
Yeah.
vis-a-vis the company limited by guarantee, which by definition doesn't have any shareholders.
yes.
What's the status of your clients by reference to the company? They're not shareholders because
No.
there are no shareholders. They're not directors. What are they vis-a-vis the company?
We say they are people with the closest and indeed sufficient interest, to use the language of Mr. Justice Briggs, to bring a claim.
I'm not sure that necessarily
I mean,
answers the
yeah.
point. I mean, they're members of the scheme, aren't they? They're members of
They're members of the scheme,
which is administered, of which the company is the corporate trustee. So their status vis-a-vis the company is that they're members of the scheme.
yes. Now, if the court is with me that a member of USSL,
But they're not
Has-
members of USSL,
Sorry?
they're members of the USS.
I agree, and this is my point. If the court is with me that a member of USSL, the hypothetical individual director, is entitled or can seek to avail him or herself of the statutory procedure under section 260, that is an important starting point for conceptualising this claim.
Speaking for myself, I have no problem at all with the concept that a member in the corporate sense of the company would be entitled to use the statutory scheme which exists for members of a company. I'd be very surprised if it was anything other than that.
Exactly.
I see your clients as complete strangers to the company.
What I'm seeking
They
to
are neither directors nor members. They have no status in relation to the company at all.
That's why I asked the question, Mr. Grant.
Yes, certainly. Well, starting with that paradigm position, the next stage in the argument is that on the assumption that no member of USSL, the company, will bring a claim, for the reasons I've set out, and then it has to say who then could bring.
Or could I? Could I bring a claim on behalf of the company in this case?
Without I'm not trying to sound facetious at all, my lord, without knowing any other circumstance
Okay, well,
pertaining to it.
you know,
And a stranger to the claim, I say, couldn't bring a claim.
right, so I couldn't.
Yes, because
I'm a
the,
complete
yes,
stranger, I'm not
Yes.
in any of the professions that
yes.
we've talked about before. So what is it that makes it your clients able to do so? And the answer is that they are beneficiaries of the trust, isn't it? That's your argument.
Yes, and it's that which gives them the sufficient and the closest interest to the claim. Because of the structure, there are no shareholders, no one above. There is no one else one can go within a corporate framework. Someone has to look
Not
elsewhere.
within the corporate framework. This is where I have
Yes.
the greatest trouble. Because the only thing that differentiates your clients from complete strangers is that they are beneficiaries under a trust. And beneficiaries under a trust have long had the ability to bring derivative claims, but pursuant to a different set of criteria and different rules.
Yeah, and that's the Robertson-Gill
Correct.
line of authority, yes.
So why aren't you following?
Because one starts from the starting point that the ordinary derivative claim is the statutory claim, as we've just said.
No, in fact, actually, the ordinary derivative claims is trust derivative claim, beneficiary derivative claims, probably where it all in a sense kicked off.
Well,
They were claims in equity, not
No.
claims under the Companies Act.
can I start from an alternative position, try and persuade the court, and then I'll invite the court to read our written document on Roberts and Gill. What the claim is really about is alleged breaches of sections 171 and following of the Companies Act by directors. Those duties are only owed to the company, so the starting point is for the company to bring. One accepts that the company won't bring that because it's the very same individuals who were involved in the alleged breaches. The next stage in the inquiry is to look for the statutory multiple derivative claim rate, which is theoretically possible, but not the current constitution of USSL, by which I mean the individuals who are there. In which case, I say that if that were the answer, and there were no one else who were able to bring a derivative claim on behalf of USSL as the company, that would be unjust, as unjust of all the circumstances set out by Lord Denning in Wallerstein and Moyer, Lord Justice Brown Wilkinson in Erkham and the other cases. The point of a derivative claim is to fill a gap, to breach or remedy the injustice when there is no one to bring a claim, which is what I say is the position here in relation to those breaches of the Companies Act, the alleged breaches of the Companies Act.
But the if we look back at the beneficiaries' derivative claim, the beneficiaries would be saying we wish to stand in the shoes of the trustee company in order to right a wrong which the trustee company is not pursuing but ought to pursue. And therefore in that model, the beneficiary could say, and therefore I wish to sue on behalf of the trustee company, the directors of the trustee company. So there is another formula that is the let's call it the beneficiary derivative formula. So it's not so that you can't get to the directors by any other means, just that unless someone begins a derivative claim, it seems as if, according to the way in which the pleadings are set out, the alleged breaches of trust by the directors will go unanswered. But because it doesn't mean that you have to follow, we're back to the same Gill point, that you have to follow the company derivative route rather than the beneficiary route, which enables the beneficiary to show that they're the right person to bring an action on behalf of the trustee company, which the trustee company is not bringing. There's nothing wrong with that model, is there, Mr. Grant?
Well, with respect there is, because it starts from, if you start from the point that the paradigm derivative claim is the claim by the member of USSL, section 260.
No.
Yes.
What is wrong with saying, forget about section 260, what is wrong with saying that as a beneficiary of this trust, I wish on behalf of my trust company to commence an action, and the action is in fact against the directors of the trust company for breach of their statutory duties to that company, but I'm going to do that wearing my beneficiary hat, and therefore I'm going to ask to be a representative beneficiary in the sense of to represent my trust company and bring that claim. To use that model, does that work or does it fail?
I say it fails because it's tantamount, first of all, to a dogleg claim.
Yeah.
Because it's a direct claim by the beneficiaries, not against the trustee, but against the directors of the trust.
Yes.
And HR and JAPT and other cases say, no, that can't work, because you're seeking to fix the directors with duties to a person other than to whom they ordinarily the duties. The ordinarily being, of course, the company, not to the beneficiaries. The other point is, sorry, let me deal with.
Do we have HR and JAP in the?
We don't, no.
Well, perhaps you would bring it after the shorter Jamet for me.
Certainly.
Thank
we'll do
you.
that. Yes. The other point is this, that the Robertson-Gill framework has been used in a wide variety of cases. It can be used for claims against third-party debtors. It can be used frequently for advisors. Robertson Gill itself, Bradstock and Damara Nathanson, lots of other cases like that. It's not used, as far as I'm aware, in claims against directors. That is the company
So the
framework.
difference is the directors, you say?
Yes. Now, would it be helpful to turn to the written document we handed up this morning on Robertson Gill? I'm not sure whether, my lord, the court's concern was triggered by reading the order of Mr. Justice Leech in December 2021, or quite independently of that.
I think it was triggered by reading your pleading,
Yes.
which, to my mind, entirely conflates or confuses the fund, trust fund, and the company as a legal entity when it comes to identifying loss. I mean, I don't want to take you back to Wallersteiner and Moyer, but in many ways we could argue this case completely by reference to the paragraphs you just took us to, by asking questions such as, who do you say is the person damnified in this case? To use Lord Denning's phrase. Who is the one person damnified in this case who, without the ability for proceedings to be brought, would suffer the injustice?
We say it's the company.
Company. Okay, so is this right, that none of the members of the pension trust fund will be entitled to benefit from any damages which would be recovered in this claim?
No, that doesn't follow. Because the company exists for the sole purpose of being trustee of the scheme.
Yeah, so your claim is a trust claim. I mean, in fact, the company exists as a corporate entity with outside creditors which it needs to pay because it's contracted for services. And it does exist with members. It does have members who would be entitled to share in any surplus. They would be entitled to share in surplus. The problem, I think, though, is that the company is set up so as not to make a profit.
Yes.
Which demonstrates, doesn't it, that its sole purpose is to act as trustee.
And Article 74 of the Articles of Association make quite clear that the members cannot profit from any surplus, and any surplus goes to charity.
Okay, goes to charity then, fine.
Yes.
But what it illustrates is that there is a separate corporate entity conducting corporate activity, and there is the trust. And when you say that the company suffers loss in your pleading, I, for one, would like to understand exactly what loss you say the company as an entity suffers. It seems to me throughout what you are actually complaining about is, you say, a loss to the beneficiaries of the pension trust. And that, I think, is different at the moment.
Can I seek to answer those questions in the context of going through the paper we handed up this morning?
Yeah, because but that's what I just put my card on the table to
And I understand. I'm
for
grateful
myself,
for your lordship to do so.
For myself, you see, I see this as a trust case.
Yes.
I can see that the company might have suffered a loss in this sense, that it, as the corporate trustee, if it's in breach of trust in doing what it's done, then it might be liable to the trust fund. But it's effectively the same point, isn't it?
Yep.
The real loss is the loss, because either there is a loss to the trust fund or there isn't. And if there isn't a loss to the trust fund, then there can't, on any view, be a loss to the company, because, for example, it's liable to the trust fund. Anyway, shall we read your?
Yes, and we can either read it together.
Read
or
it to ourselves.
I'm happy either way, my lord. I mean, at some points we've already covered, but it may
Why
be.
don't we just read it to ourselves?
Certainly.
And then you make submissions as you wish.
perhaps be appropriate to make a few additional points. The claimants are not complete strangers to the company. They contribute capital, and they are the people for whose objects the company exists.
Sorry, the
Yeah.
claimants contribute capital to the company. They don't.
With respect
The
to,
company has no share capital.
no, but we can see in the bundle in both there are USS and USS accounts. And of course the contributions which the members and all other active members make.
What is the share capital? There is no share
No,
capital.
it's not.
They make contributions to the fund,
They contribute capital to the fund, not to the company.
and the fund then gives monies to the company, so that the company can run them.
Yes.
And that's the point.
Sorry, you said that your claimants contribute capital to the company.
Yeah.
Unless I misheard you.
I did, but I didn't mean it in that sense. I meant they provide contributions.
They make contributions
contributions, yes.
like
Yes.
members always do,
Yes, of
or
course.
often, more often than
Yes.
not do.
Yes.
And therefore it's accepted that of course therefore they have an interest and they are not strangers to the fund, and that they've given consideration in many ways for their pension benefits. In this case, are you saying, Mr. Grant, that they actually pay their contributions through the conduit of an accounts company, and that's why you're saying they pay capital, in the sense that they pay their contributions to USSL accounts or something, which then puts it back into the fund, is that right?
No, I'm not making such a specific point on the mechanics of the payment. I'm simply making the point that, as was made in McDonald and Horn, beneficiaries of pension scheme are analogous to shareholders in that they are not volunteers. They make contributions.
But that's vis-a-vis the fund, vis-a-vis the pension fund.
But under Article 171,
Volunteers,
If
vis-a-vis
you
the fund.
just said your
Yeah.
claimants contribute capital to the trust fund, I would have not even bothered to write it down because that's uncontroversial. What you actually said, with respect, was
Yeah.
both wrong and very controversial.
Do you want us to look at the trust deed?
well, it would be helpful first of all to look at the Articles of Memorandum of Association.
Right.
Supplemental,
Of the company.
Supplemental Bundle 2,
Yeah.
tab 25.
Yeah.
We're really concerned with Articles 71 and 74. But if we start with Article 2, page 110.
Sorry, Article.
Article 2, page 110. Automatic member of the company. Move on to Article 71, page 121. Sets out the objects for which the company is established.
Article 71.
Count generally in terms of any pension scheme. But clearly in the reality it means the USS scheme.
Yeah.
Then Article 74 over the page. Income and property of the company.
Just to be clear, the income and the property of the company does not include the trust fund, pension fund.
Well,
the company does not own officially the trust fund.
no, it holds it on trust. Yes, but
So when it says the income and property of the company shall be applied towards promotion of the objects of the company, that's talking about income or property of the company in its corporate not in its capacity as trustee.
But it has no
Well, yes, it
property.
does. Well, it incurs liabilities, for example, to advisors and to staff in the running of its business as being a trustee company, and it derives income in order to discharge those liabilities. In other words, it charges fees to the trust fund.
Yeah.
So this is dealing with income and property which it holds in its own right to discharge liability which it incurs in its own right, surely.
But it still goes back, even if that is right, it still goes back to the promotion of the objects of the company,
Yeah,
which
which is
are
to act as a trustee.
trustee,
Yeah.
yes.
Yeah.
Yes.
But
So, for example, if the company employs a firm of solicitors to act on its behalf as trustee, then it will need to pay those solicitors from income, and that income will come from the fees that it charges the fund for being corporate trustee.
Or even the subject of claim 3, the costs claim in this proceedings.
Yeah.
Yes.
yeah, but just to be very clear, this is not property which belongs in a small part to your clients.
Can I ask the court to take up Composite Authority Bundle 1, simply to go to section 172 of the Companies Act?
Are you going to show us at some point, did you say you were going to show us the accounts?
No, I wasn't going to.
Because just to be clear, I've not looked at them, but I would imagine that there are financial statements for the trust fund, i.e. the pension scheme, which are pension scheme statements. And there are presumably statutory accounts drawn up by the company.
Yes, there, perhaps we can.
The company's accounts, the statutory accounts drawn up by the company, do not include as an asset of the company the pension fund.
Perhaps we stay within Supplemental Bundle 2 for the moment. Tab 46.
Tab
46, page 479. That's the group report and accounts.
Tab 46.
Sorry, it's the supplemental
It's in
bundle.
Part B, I think.
is the other
Dot.
Yes, I apologise. I will have it in one bundle.
46.
46, my lord, yes. So that's the group report and accounts for the company. And we see, for example, page 486, the total operating costs.
Yeah.
And balance sheet to page 495. Cash flow statement, page 496.
Sorry, which page do you want for the...
Sorry. 495, my lord. See the balance sheets there. 496, the cash flow statements. That's the company group accounts. The report and accounts for the scheme are at tab 47.
A different order of magnitude, if I can put it that way, in terms of
They're in the billions rather
yes.
than in the
it rather
millions.
makes very graphically the point.
No,
The company has its own operations, which are substantial.
Yes.
Because it's a substantial trustee business run not for profit, but which has substantial liabilities and needs cash to pay them, which it derives from charging the fund. But the fund is of an order of magnitude bigger and exists for the benefit of its pensioners, the members of the scheme. And hopefully never the twain meet other than by the payment of fees from one to the other.
that's the idea, of course, yes.
80.6 billion invested in public and private markets.
Yes.
It's close to 144 million.
Indeed, yes.
Net current assets.
What I was about to do was to move away from supplemental bundle 2 to go to composite authorities bundle.
Should we do that after we've had a short break, Mr.
Certainly, yes.
Go, guys.
Don't David, we're getting copies of Jan's of Greg's draw. So we've got 7 copies.
We didn't print them below. I had them for separate viewing, not below.
I think that's right. I can't remember. I'll have a look.
Yes,
I think that's right.
This idea that I don't know why he's put it on the just thinks that it's not shared as such. That's all. That's the doctrine of property. So
Yeah.
Well, you don't actually come off. Yeah, so the live stream so it cuts off here. And so I'm on the stream, yeah. So if I'm if you want to be a YouTube star,
first question,
yeah,
it's not damages paid to the company, would it be available for security? I think that answer is absolutely on stage. And I've been checking with Richard.
yes,
And where I stood top is obviously damages the company trust, because the company is a trust corporation, but you don't need a second trust, like a constructive trust to hold the damages. It's just going to the company, and then also it's going to be doing what we do under its objects, which is provide university pensions. So I think it's just a separate that's a fair point. But it benefits indirectly, but only by coming to cost. It wouldn't be helpful constructive trust for the beneficiaries, would it? Just normally we want to claim with it. Indirectly. That's fair. But you don't need a second trust. So I think it's straightforward. Obviously, banking is this is not for the company. And the point about beneficiaries, so you could have accrued beneficiaries who are going to benefit from this claim. We've got beneficiaries who in a company you might have shareholders that have no cash rights whatsoever, right? So they're not going to benefit from the derivative action or by shareholders that do get cash as a result. So you've always got different classes, and the filter process is what gives the court the opportunities that are sufficiently representative. So we have to make it it's far better. Yeah, I mean, what I think was exciting because Lord Justice Snowden came back to us. But also it's a shame that the document code, which I think is excellent. Yeah.
Because this might not just
don't get it hung up on capital, it's just the only question is obviously to the qualified stakeholder, the filter process is
And so that's the loss to
to provide for the ordinary development. That's the question. To the trustee. Well, Esmanco could.
That's basically it. So yeah, not about
Well, exactly. Who is the beneficiary of her? And then how do you test that? Well, it has to be a redempted. So you've got that. You're familiar with redempted? Yeah. So then the do you want to propose just claim an abstract purpose?
I have to
Express.
So I haven't been.
Beneficial purpose you will have standard as a trust. Redemptive features in those submissions.
Corais?
You can take us to the authorities part.
Yeah, just as the court rose, I was handed a note saying that transcribers don't need a break, but that was academic in the second session.
Well, perhaps
Yes.
we did.
Yes. Yes, so composite bundle, volume 1, tab 5. This is the Companies Act, section 172.
Yeah.
Duty to promote the success of the company. Subsection 1 is the general proposition, the orthodox company, if I can call it that. The director of a company must act in the way he considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole, and in doing so have regard, amongst other matters, to A, B, C, D, E, F. Consequence of the decision, the interest of the company's employees, fostering business relationships. D, the impact of the company's operation in the community and the environment. E, desirability of the company maintaining a reputation for high standards of business conduct. And F, the need to act fairly as between members of the company. Subsection 2, where or to the extent that the purposes of the company consist of or include purposes other than the benefit of its members, which I say is clearly this case. Subsection 1 has effect as if the reference to promoting the success of the company for the benefits of its members were to achieving those purposes. And so, this is significant in trying to establish what right my clients have to bring a claim on behalf of the company. See, they're not complete strangers to the fund, by extension to the company. The test in Fort Gilkicker, which Justice Briggs identified, is showing a sufficient interest. True that was a case involving a vertical line of shareholding ownership, but the wording is much broader than that and is identifying a point of principle, someone with sufficient interest. I say, amongst other things, that shows why one doesn't necessarily have to have reflective loss, frequent though that will be in the case of companies limited by shares. All one has to have is a sufficient interest. And I say here that 2 active members of the scheme have the closest possible interest. One accepts the statutory claim is not possible. There's no one else, no other way of filling that gap, that potential injustice. One has to look elsewhere, and one finds the people for whose benefit the company is operated. one finds a parallel in the case of Est Manco, which is the only example of a company, a not-for-profit company, where a derivative claim has been brought. Might be helpful to go to that.
Where's that?
Now, that's in the core bundle of authorities. Tab 6. There are a few particular quirks to this, which I'll try and cover as briefly possible. So the company, what the judge below calls the subject company, is Est Manco Kilner House Limited, who was the original plaintiff, as it were. Greater London Council were as shareholders. It was a claim against a shareholder. That was a point recognised by the Vice-Chancellor, and nothing turned on it. Effectively, the application was brought by a non-voting shareholder, Ms. Frances Cope, to replace the company in bringing the claim on its behalf as GLC tried to renege upon an agreement to transfer properties into the company's name. A very, very brief summary of the matter. This is a case primarily we rely upon for the test of furthering their ends, establishing that a financial benefit is not required. And we'll come to that in due course. But in terms of an analogy to the situation which is currently troubling the court, this, in my submission, is the closest example, because imagine that Est Manco Kilner House Limited had been a company limited by guarantee. Would that have had any impact on the nature of the claim or the outcome of the grant of permission for Ms. Cope to be replaced as claimant on behalf of the company? I say it wouldn't have, because the reality is that she was seeking to bring a claim on behalf of the company. The company existed for her, for the purpose of her and the other flat owners. One can analogize between that company for the purpose of, and potentially for the trust and company for the purpose of, we have in the Universities Superannuation Scheme. But I say it reinforces the point that one has to look at the purposes for which a company operates. In that case, it was really to effect the transfer of the flats into the ownership of these individuals. Here we say the purpose of USSL is to operate the scheme. Its function is to operate the scheme on behalf of the members of the scheme. And all those members, no matter whether they are pensioners, deferreds, actives, or anything else. Perhaps now is the time to answer head-on the question which my Lord Justice Snowden has asked several times about for whose benefit any damages. They would be, the company would hold them, they would be potentially available for unsecured creditors.
So you are saying that they therefore are designed to remedy a loss which the company suffers itself in its
Yes.
own corporate
Yes.
capacity. What is that loss?
Well, ultimately, it's the loss of the right of directors to abide by their statutory duties, section 171 and following.
No, that's the duty. What's the loss that, I mean, we'll get onto this when we look at your pleading.
Yes.
What is the loss that you say the company as an entity suffers that would justify any recoveries in damages being held for the benefit of, say, its unsecured creditors?
Well, it would depend upon which claim we're concerned with. But for claim one, it would be the valuation of the scheme, which leads to the diminution of assets and the increase of liabilities, and ultimately an increase in deficit.
That's the scheme. That's got nothing to do with the company, as we just, by looking at the accounts we've just demonstrated.
Yeah.
That's got nothing to do with the company's assets. The company suffers no loss.
So if you were right about
Yes.
that, and then the unsecured creditors of the company get a windfall because they recovered the damages which
on that hypothesis, actually constitute a loss suffered by the fund. I mean, complete confusion between the two, Mr. Grant.
Well, my lord, we've sought to identify.
You have surprised me with your answer because, as I very clearly understood, I think, the entire basis of your client's interest in this case is that they say that their interests as beneficiaries of the scheme have been prejudiced. And that's why they say they are interested in seeking to remedy the injustice. And therefore, unless the losses or any recoveries to compensate for those losses were suffered by the scheme, I'm really struggling to understand why they've got anything to do with this.
Well, even on, as I said, even on the basis that the losses, any damages were recovered were held by the company, nonetheless, that has an impact on the indemnity as between the scheme and the company.
Well, you see, now we're beginning to get a bit more close to, if
Yes.
I may think, what's going on here.
Yes.
The only loss, in inverted commas, that the company could suffer as a consequence of the breach of duties of its directors, as you've identified, is that the company is exposed to a claim for breach of trust to the beneficiaries of the scheme. That's the point. You're saying, by reason of the breach of duties of the directors to the company's loss is that it's exposed to liability for a breach of trust claim to people who include your clients.
Well, certainly that's expressly how Claim 2 is framed, which is the
Yeah.
potential of a discrimination claim.
Claim 3 is, in fact, a rather good illustration of the problem you face, because Claim 3 is that the company's been paid too much money by way of fees. And
So did you also say paid or paying?
Claim 3, as I
Yes.
understand it, is that the fees that the company is paid by the scheme are too great. That's Claim 3.
So the only reason is I thought your lordship said
Sorry.
paying.
Sorry, no,
Which is why my-
sorry, okay.
yes.
Yeah.
Yes.
Claim 3 is the fund has been overcharged by the company by way of fees for administering the scheme, yes? So, who suffered the loss there, if you're right, on your allegation?
Well, I say both. I say the company and by extension the scheme.
Well, no, hang on, I thought you said the company's been, the hypothesis is the company's been overcharging the scheme. Who has suffered the loss?
On that paragraph, then the answer is the scheme.
Well, the point about the third claim is it said various people who have acted in various professional capacities vis-a-vis the acting by the company as trustee have been overpaid, but the conduit by which they get overpaid is that the company
Yes.
gets its money from the fund and pays it to either to its own employees or to third-party contractors. So the company doesn't actually suffer any loss at all, because everything that it pays out, it comes from the fund. It's the fund who suffered the loss.
So it's a breach of trust claim, is that right?
Well, I say some of these could be put as breach of trust claims, but the way we have framed.
Well, you framed it as a breach, I know you framed it as the company suing its directors for breach of their Section 172 duties. Of course I get that.
Yes.
Of course I get that's what we're looking at. But when you try and identify the loss, which is said to lie at the heart of your entitlement declarations you seek, and indeed is reflected in the terms of the declarations you seek, the loss is not suffered by the company. It's loss which is suffered by the fund. And the overcharge claim, Claim 3, is probably the best illustration of that, because you're complaining that the company has been paid too much. It's certainly not suffered a loss.
But then there are potential ways in which a claim could be brought. So one is the mechanism we are seeking to follow at the moment. Second, I just outline them and then go into detail in these. Second is breach of trust claim. And the third, and that would be against USSL. And the third would be dogleg claim by the beneficiaries effectively seeking to bring a direct claim against the directors. Now, Mr. Justice Leech initially thought that this was a dogleg claim, and it appeared that I persuaded him that it wasn't, because we're not seeking to extend the duty of the directors to anyone other than the company, which is the people, to the entity to whom they own their duties.
You're trying to stand in the position of the company
Exactly.
in order to sue the directors.
Yes.
You are not saying that the directors' duties are owed to the beneficiaries.
No.
You are saying we, as individual members of the, I'm sorry, I
Yes.
know, I'm just, please tell me when I go wrong.
You know.
And you are saying we, the beneficiaries, want to stand in the place of the company to sue the directors. That's it.
Yes. And with the dogleg claim, the HR and JAP claim, which I understand, I think the other side are helpfully going to produce, it was before Mr. Justice Leech at the first hearing in February last year, but not, from recollection, in March. The difficulty with that is the difficulty I've already explained, pinning a duty on someone other than the entity to whom they owe the duty, and it is significantly different from a derivative claim, because for that very reason, a derivative claim simply seeks to bring a claim on behalf of the person in whom the claim is constituted for procedural reasons.
And that's a bit of a cul-de-sac here,
Yes.
the dogleg claim, isn't it?
Yes.
In the sense that that's not what you're trying to do,
No.
number one, and B, that's not how you pleaded it.
No.
You're not suggesting duties are owed to the beneficiaries, you're asking for the beneficiaries to stand in the place of the company.
Indeed, yes.
So that's a bit of a red herring, I
Yes.
think.
Yes.
Let's
Yeah.
let's assume, and I hope that actually I was going to use the solicitors as an example, but perhaps I won't. Let's assume that an investment advisor to the company in this case first of all enters into a contract with the company to give investment advice in relation to the activities of the fund. Yep. And there's an express contractual duty of care in the contract, which there probably will be, and maybe some duties which might, in other circumstances, be regarded as fiduciary duties. In other words, you don't seek to profit from your position as investment advisor to the company in relation to the fund. I think it's fairly clear, hopefully, what I'm talking about.
So this is a contract between the company and external advisor.
Correct.
Yes.
And if that external advisor breaches the contract, either by failing to take adequate care or makes a secret profit by front-running some with other clients, some in big investment decision that the fund's going to make, the company would have a breach of contract and possibly a breach of fiduciary duty claim against the investment advisor. If the trust company decides not to pursue the claim because its directors, who are not involved in this at all, consider it's uneconomic or the prospects for success are not good enough, first of all, could your clients seek to pursue that claim on behalf of the company?
Yes, they could. But the mechanism by which that would be done, that would be, I think, through a Robertson-Gill style claim.
Right, well that was,
Yes.
you're ahead of me.
No. Well, that's the first time
That's
this morning.
exactly the question I was going to ask you.
Yes.
So what differentiates that position from the current situation?
Because that situation is aligned with all the other examples in Robertson-Gill and the passage in Lewin. It's claims against third parties, whether it's advisors, whether it's debtors, whoever. It's not a claim against the directors, which is a claim brought by the company, qua company, against the directors as directors. And that is the distinction.
But the claim in the example I gave you is a
Yes.
claim brought by the company, qua company, against an external advisor.
Yes.
I mean, in fact, the investment manager, who probably actually is rather more closely connected with the activities of the trust fund than.
And the loss that the company suffered in that example is exactly the same loss as you
Yes.
have to demonstrate and suffer
Yes.
here. Namely, that the company has suffered a loss because it's been put in breach of trust, and therefore it's liable to the fund.
But I say that what it comes down to is the nature of the underlying claim. A claim by a company or on behalf of a company against directors, historically for breach of their equitable duties, now the codified statutory duties, that is a claim which engages Foss and Harbottle, or any exception to that. Someone other than the company seeking to bring the claim engages the exception to Foss and Harbottle. A claim against against third parties, whether they be professional advisors, whether they be other contracting parties, whatever it is, that is a claim which doesn't involve the Foss and Harbottle exception, but would involve if the ordinary claimant were a trustee, whether it's a trustee company or individual trustees, that would be the Robertson-Gill test. I say that is fundamentally the difference. It's the fact that it's a claim on behalf of the company against the directors. And that's why in Popley, that ultimately was a claim concerning a company, but the way it was that ultimately the shares were held by a trustee company who held, in fact, the shares of both sides of the family. So not only was there a company derivative aspect, as set out in the note handed up this morning, but there was also a trust aspect to it, because there are two substitutions or placements taking place. One is the ability of someone other than the company bringing a claim against the defendant, the brother Ronald, I think it is. The other aspect is at the top of the vertical chain of ownership. It's someone other than the trustee bringing in the claim, because the trustee in fact applied for permission to discontinue the claim. Those are two separate placements or substitutions taking place. One is within a corporate context, the other is within a trust context.
Speaking for myself, I think we need to, if we're going to go to Popley, we'll do it presumably by looking at it.
Yes.
Just finishing with Asplin Co, following on from my questions. Asplin Co, first of all, the derivative claimant was a member of the company.
Yes.
And the wrongdoer, in inverted commas, was a third party, namely the council that was refusing to perform the contract which it had entered into, wasn't it?
Yes, it was a claim against the shareholder, not against the directors.
Right. In
Yes.
other words, it's
Yes.
for this purpose, the fact it was a shareholder, I think you said.
Incidental, I think was the word I used.
Yes. I said it doesn't matter.
No.
For this purpose, it's a third. So this was a derivative claim by a member of the company,
Yes.
in right of the company,
Yeah.
against a third party.
Yes.
So how does it help us in our case?
Because it reinforces two things. The direct point, the point I've tried to make already, is that it reinforces the concept of the purpose of the company. There's the analogy there. The fact that it was a company limited by shares is, again, incidental because it was a not-for-profit company. Had it been structured as a company limited by guarantee, wouldn't have made any difference. The other point is this, which I haven't made so far, now maybe an appropriate point to make it. Imagine that the facts were slightly varied, so rather than being the shareholder, GLC, who resolved for the claim not to continue, but it had been the three directors who made that resolution, that would have been a claim against the directors, but effectively for the very same purposes. So in there, the fact that it was a claim against the shareholder is incidental. The claim could have happened if there'd been a quirk of facts as a claim against the directors as being the people trying to prevent the company from enforcing its contract.
Okay, so
But I'm slightly lost, and I apologise, Mr. Grant, that Esmanco was a Foss and Harbottle case.
Yes.
Yeah.
Exactly. And in that case, it's being said that the wrongdoer was the third party or was a shareholder.
Yes.
It's GLC who's changed their policy, etc. And you said that didn't matter one way or another. And it had been analysed a few moments ago as the wrongdoer being a third party. But you said earlier that the difference here is not the situation that my Lord Justice Snowden went through with you a little earlier. The difference is that here the wrongdoing is breaches of duty by the directors. But what is really the difference, therefore, that you would pinpoint for me between the situation that we have here, which you say is very different and must be a company derivative claim, and the situation in Esmanco, and where you also said when it's against a third party, which I think is what you just said about Esmanco, it's not Foss and Harbottle, I've written down. So I'm a bit confused. I'm sorry about that.
The reason is because when I was making the distinction between third parties and others, that was in the context where the claim is by a trustee company. So Bradstock, Robertson Gill, all the other cases set out in Lewin and referred there, those are claims by trusts, whether individual trusts or a corporate trustee, doesn't make any difference. Not seeking to take that point. Nonetheless, claims by a trust, ordinarily the trustee is the person whom the claim is vested, doesn't, can't, won't, whatever may be in the facts of any specific case. So a beneficiary potentially can bring a claim if there are special circumstances.
Yeah, you're in the beneficiary
You're in that context.
derivative, let's call it that.
Yes.
Yeah.
But they're all to do with third parties. They're not claims being brought by a company, which happens to be a trustee company, against directors. The factual differences of Esmanco have no impact on the application of Robertson Gill, because Esmanco is, as your lady said, a Foss and Harbottle claim.
Yep.
So it may have brought the scope of a claim wider than hitherto had been understood, because it extends to a claim against a shareholder. It's not limited to a claim against a director. But that didn't matter.
In other words, I think if I put it a slightly different way, that the Foss and Harbottle, the exception to the Foss and Harbottle rule applies both if the corporate cause of action is being prevented by wrongdoers who are directors or by wrongdoers who are shareholders, using whichever corporate mechanism they can use. In many cases, the directors will just say, we're not causing the company to sue ourselves, which you say is this case. In Esmanco, it happened that the wrongdoer was a shareholder and can pass a resolution directing the directors not to pursue the claim.
Yeah, that's a much better way of putting it, because it gets to the same result, whether at board level or member level.
It's looking at wrongdoer control.
Indeed, the claim is blocked.
Yeah.
As I say here, there is clear, based on allegations, wrongdoer control because of the Article 2 of the Articles of Association. The directors are automatically members.
I mean, the same principle of sort of wrongdoer control comes in, as we'll see in Robertson Gill, doesn't it? I mean, it's basically, the trustee is said to be the wrongdoer and won't sue itself.
Or someone at their bidding. So
yes.
Popley, again, perhaps now there's time to go to Popley, but what happened there was the trustee company that was trust of both family trusts, John Seniors, who was the plaintiff, and Ronald, who was the defendant. The claim was vested or bought and assigned, I think, to that trustee company, who on the instructions doubtless of Ronald, the alleged wrongdoer, intimated that it was going to apply to discontinue the claim. So again, it's at the bidding or controlled by the wrongdoer. So yes, of course, in a lot of those trust cases, same concepts will apply, but that's just a function of the same motivation to do justice when there is wrongdoer control. It's not with respect to an answer as to which paradigm of derivative claim this is. What I had hoped to do was now to move on to the submissions I was anticipating in making. We've already touched on some of them, but to try and make up time as quickly as I can in order to do my case and my client's justice. I started off identifying this concern about injustice in some of the cases. Lord Justice Hoffman said in MacDonald and Horn, and I can take you to it, and this is the point that we've already made, so it may not be necessary. The point about a derivative claim is that the plaintiff is asserting a cause of action which really belongs to a different person, namely the company. He has no substantive cause of action of his own. And that's reflected in lots of other cases. In the interest of time, I won't take you to them. I say that the interest of justice is the rationale, but it's clearly not the test as to when an exception to Foss and Harbottle has been engaged. But I say that the aim should be a test which is wide enough to comprehend all the exceptions, but be narrow enough to be practicable and workable. And if we're still in Estmanco, perhaps...
What McGaughey says in terms, it's not the test.
Yes, he says it's not the test, and then he identifies the aspiration, which I just paraphrased, which is that the aim should be to have a test which comprehends all the exceptions, but nonetheless is sufficiently narrow to be practical and workable. And I say that must include cases of companies limited by guarantee. It must include however many limbs there are of subsidiaries in the classic vertical derivative claim structure. It may have to incorporate other factual situations which have yet to trouble the courts. But in terms of a claim which the company here could bring against or could be brought by or on behalf of the company against the directors, there are a limited number of possibilities. Starting point, claim by the company itself. Next logical option would be a claim by the members of USSL. Bringing that claim would be a statutory claim. In an insolvency situation, there would be the possibility of the liquidator bringing a claim. That's clearly not the situation here, but that is the context for some of the wrongdoer control cases we're going to come to, hopefully before the short adjournment. None of those is an option, one way or the other. So we say the only realistic option of a claim being brought on behalf of the on behalf of the company is this claim which my clients are seeking to bring, namely a derivative claim on the company's behalf. Very briefly, historically there was no requirement for permission. What tended to happen was that claims were brought, and if the defendants objected to it, they would apply for strikeout. One can see that from cases such as Daniels and Daniels in the bundle. Two significant developments. One is the introduction of permission into the rules of the Supreme Court in 1994 and 1995, and the second is the statutory test. Incidentally, and for the court's note, the requirement for permission was introduced in the mid-1990s. In Boston Trust, Sir David Richards says it was introduced in 2000, scheduled to the CPR. That's not correct. That's when it became part of the CPR, but it had hitherto been part of the procedural framework for the previous 5 years. Historically, the cases were all direct derivative claims, even before the vast majority of them were direct derivative claims, even before the Companies Act 2006. It's clear as a consequence of Fort Gilkicker that the derivative action was flexible enough to include as a derivative claimant someone other than a member when the company in its wrongdoer control. And for that I rely upon Fort Gilkicker, paragraphs 24 to 26. The justification for that is as follows. Primarily, in that case, when the shareholders will not sue, or I say, fi fortiori, where there are no shareholders, the reasons I've already outlined. As a matter of terminology, I've touched on this already, claims been described variously as double derivative claims, multiple derivative claims. In fact, I would endorse what Mr. Justice Leech says in paragraph 17 to 20 of the judgment below. It's quite clear that Mr. Justice Briggs in Fort Gilkicker thought this was a matter of classification only. I'm now going to turn to Fort Gilkicker very briefly, just to, in fact, actually, no, I won't. I'll take you to the judgment under appeal, which is in the core bundle at tab 16, just to see what was common ground below, and what the judge held. Paragraph 21, it's page 175 of the core bundle. That accurately recognises the common ground of counsel that the categories of multiple derivative claims were not closed. Derivative claims no more than a procedural device to avoid the injustice which would occur when a wrong is suffered for which no redress could be claimed by an affected party. Already taking you to Wallersteiner and Moyer. Paragraph 22, similar well, it refers to Nurkham and Nurkham. Paragraph 22 then sets out an extract from Justice Briggs in Fort Gilkicker itself. I think we have covered all of that already. And at paragraph 28, then a judge records, rather, the absence of submission by my learned friend, namely there could never be, namely the term it's possible, positive, for members of a pension scheme to bring a multiple derivative claim of the sort contemplated. And he held in his judgment that the company was right not to advance the contrary argument. The examples he gives, though, are really ones of misappropriation of assets on an industrial scale. And I say that that limits the point too much. Effectively, because if that is what is required, the test can never be met in the case of a company limited by guarantee and or in relation to a pension scheme. The question of ground A, the grounds of appeal, is whether there is a threshold requirement of reflective loss. As I've already said, the question is simply whether the claimants have the closest sufficient interest to litigate on behalf of the company. That's from paragraph 44 of Ms. Justice Briggs' judgment in Fort Gilkicker.
44?
44.
Thank you.
And I say, drawing together much what I said this morning, that the claimants here have a much simpler and closer nexus than some of the other cases I've referred to, which have a complex corporate structure of ownership with interminable holding companies, LLPs, trusts, and the like. Ground A, then, the ground of appeal is that the judge erred at paragraph 30 in introducing into the test of whether a claimant has standing to bring a derivative claim the requirements that, I quote, the subject company has suffered a loss, and this loss is reflective of their own loss. I say that that is wrong as a matter of precedent and principle. First of all, reflective loss was first recognised or articulated in the Court of Appeal in Prudential in 1982. That's the core bundle, tab 5. It may not be necessary to go to it because it should be recognised that well known that that is the first time that reflective loss was articulated, point considered in Marex and Sukania and Burnford, in which cases two of the members of this court were involved. There is no mention of reflective loss in derivative claims until the Hong Kong case of Waddington, which is in the core bundle tab 11, which I will invite the court to turn to.
So, and that's at
Core bundle, my lady, tab 11.
11, thank you.
We're almost exclusively concerned with the judgment of Lord Millet in the Hong Kong Court of Final Appeal. That is a case where the claimant was seeking to bring two derivative claims, one on behalf of a subsidiary, that's Defendant 3, and one on behalf of a sub-subsidiary, that's Defendant 5. The first claim was held to fail for reflective loss. The second claim succeeded. I say, contrary to the judge's holding below, Lord Millet did not impose or apply a requirement of reflective loss. First paragraph to turn to is paragraph 74. As he says in the first few lines, page 244, this is highlighted in the red line. The question is simply a question of the plaintiff standing to sue. On a question of standing, the court must ask itself whether the plaintiff has a legitimate interest in the relief claimed, sufficient to justify him in bringing proceedings to obtain it. I'm reading a bit on. He says, the answer in the case of person wishing to bring a multiple derivative action is plainly yes. Any depletion of subsidiaries' assets causes indirect loss to its parent company and its shareholders. In either case, the loss is merely reflective loss, mirroring the loss directly sustained by the subsidiary, and as such is not recoverable by the parent company or its shareholders for the reasons set out in Johnson and Gore Wood. Lord Millet then went on to explain how the depletion of subsidiaries' assets leading to indirect reflective loss on the part of a parent is not recoverable on the grounds of public policy, but why that rule of public policy did not mean that the parent hadn't suffered any loss as a matter of law or economics.
But what he goes on to say is it impossible to understand the last sentence of the paragraph. Impossible to understand how a person who has sustained a real, albeit reflective loss, which is legally recoverable only by a subsidiary, can be said to have no legitimate or sufficient interest to bring proceedings on behalf of the subsidiary.
Yeah.
So that clearly is saying that the claimant has to have suffered a real loss. The claimant has to have suffered a real loss, even though it may be a reflective loss.
Yeah. With respect, it says that when such loss has been suffered, that will be sufficient to make the individual a suitable claimant to bring the claim. It doesn't imply the converse, which is what my lord has read in, which is that the absence of any reflective loss is a necessary bar on the ability to bring a claim.
He didn't say that, does he?
No, but
It's just what you say is implicit in the position.
yes, because the way he's
Implicit
put
in what Lord Millet says is that you don't need to have suffered a loss yourself to have sufficient interest.
This debate is taking place in the context of a structure,
yes,
corporate structure,
yes,
where the factor that connects the putative claimant, in this case a shareholder of a parent company or a ultimate parent
yes,
company, with a loss suffered by a subsidiary or a sub-subsidiary. And the reason for the real interest, the real loss, is because of the corporate structure, that by the very fact of holding shares, you have a commercial piece of property and interest in the subsidiary.
yes.
So it's the structure that allows Lord Millet to say, if your subsidiary or sub-subsidiary suffers a loss because somebody removes its assets, that necessarily, because of the corporate structure, at least assuming that there are no insolvent companies in the chain
Yes.
for present purposes, which is an additional complication, which some of the other cases have dealt with. But assuming there's no insolvent companies in the chain, you can see why he says that somebody who's a shareholder in the ultimate parent has an interest because they have a piece of property, a right of their own, which is necessarily harmed or devalued by what's gone on a few layers below in the corporate structure.
I might use the word interest as opposed to right, but of course the rule against reflective loss is they don't have the ability to bring a claim. But nonetheless, I think we're going to the same content, the outcome.
And where I'm struggling at the moment is to make good that connecting factor in the current case, because in truth, there is no linking structure of the type we've just been describing.
No.
And the only reason that you say there is a linking structure, I think, is because you say that the company is exposed to a claim for breach of trust by beneficiaries by reason of what its directors caused it to do.
No, it's not quite how I put it. I say that the linkage, in the absence of any vertical corporate structure, is because the company exists for the purpose of acting as trustee of the scheme, of which my clients are members.
Right, but if we're talking about, you see, Lord Millett is talking about loss,
Yes.
and he's talking in this thing it's all about loss.
Yes.
It's all about
Yes.
loss. And the only thing that connects the loss that you say, the only loss that you say the company has suffered, and it's loss of a very unusual type, it's actually not loss as such at all, it's exposing the trustee company to a liability for breach of trust. The loss having been suffered by the beneficiaries of the trust. That's the distinction as I see it in terms of structure. And that's why I don't think Lord Millett's analysis has a direct read across to your situation at all at the moment.
Well, I'm saying it doesn't because it's talking about a different structure, and one can't take from that the fact that Lord Millett has set down a point of principle that for all companies, whether companies limited by shares or limited by guarantee, in order for someone to be a suitable person to bring a derivative claim, they need to have suffered loss reflective of the companies. I say these passages do not establish that. But that is what the judge did. He took the reasoning on its head and made reflective loss the fulcrum of the gateway test. In the cases purely on reflective loss, so Prudential, Marix, Burnford, Soprano, even if the company does not have a claim, even if the company does not bring a claim, the shareholder doesn't have a claim. The right to bring the action is in the company. If it decides not to sue, the shareholder must abide by that. And that is analogous to the concept of ratification. It goes back to the point that the decision-making is ultimately vested in the company. We know from the Supreme Court's decision in Marix that the rule of reflective loss is limited to shareholders. It has no wider reach.
So where we may be headed with this is you say that maybe the judge this is not a standing question.
Yes.
You say your clients have standing because in economic terms they were affected by what has occurred.
Indeed.
Albeit not through a structure like this.
No.
But what it does potentially then, you say, I think, is transfer the scrutiny to the question of alternative remedies or what else would make it, I hesitate to use the word special circumstances, but what would make it appropriate for your clients to be allowed to use this mechanism rather than the usual trust beneficiary type derivative claims.
Entirely, I say it's not a question of standing. it may be engaged in the question's discretion down the line for those very reasons your Lord has just identified.
You're focusing at the moment
Yes.
purely and simply on whether it's right to have said
Yes.
it's a standing question.
Exactly, yes. And I say the only question of standing for Gilker is whether the claimants have sufficient interest to bring a claim.
And you say that could be sufficient economic interest, not legal interest. Lord Bill was focusing on legal interest.
Indeed,
When he said
yes.
interest, he was focusing on legal interest in the sense of he saw there was a legally connected structure.
Yes.
You
But he
say-
also, sorry,
Yeah, you do. You're saying in reality it's a question of economic interest.
yes. Certainly, I mean, Lord Millett also recognises, he says there's a legal and economic loss. So he's not making it exclusively legal. May I turn to Aberaya now, which is the source of the proposition that reflective loss is taken as a requirement. That's again in the core bundle.
Sorry, just to put the marker down.
Certainly.
In a sense, it's been down before, but
Yes.
just reiterating for the benefit of the transcript when people are going back and looking at this. That will bring into play all the other issues, such as if your clients claim they've suffered an economic loss as a consequence of these actions by the directors, should they be entitled to use the corporate vehicle to pursue that in circumstances where other members of the scheme may have benefited from the decisions that were made?
It's engaged in at least 2 points. The next point, which is the first part of the respondent's notice, which is whether an alternative remedy is an automatic bar, which I'm going to come to shortly, and also to the alternative position of that, which is it's a discretionary factor.
Right, we're going to Aberaya.
Aberaya, my lord, tab 14 in the core bundle. Shows Mr. Justice David Richards as he was. Double derivative claim. We'll come back to it to look at, we need to, in light of my Lord Chancellor's comments earlier this morning, Esmanco, but what I'm concerned with, paragraphs 24 and 25,
Yeah.
where having referred to Esmanco and acknowledge that that's not a case of financial gain to the majority and financial loss to the company and the minority members, the judge goes on in paragraph 24 to say, it is therefore the case that all the authorities and direct derivative actions have taken as a requirement that the alleged wrongdoing should result in a loss to the company and hence an indirect or reflective loss to the shareholders. Also that the alleged wrongdoer should have personally gained for the breaches of duty. Park the question of gain for the moment to focus immediately on the question of loss. That's what his Lordship says at paragraph 24. Then over the page, he says something similar but not entirely consistent to paragraph 25. He says, it follows on the authorities as they stand that financial or other loss to the shareholders, albeit normally of a reflective character, is essential to give a claimant shareholder sufficient interest in the proceedings to make the shareholder an appropriate claimant on behalf of the company, whether he is a member of the company or of the holding company. Paragraph 24 is said in absolute terms. Paragraph 25 is said in slightly less than absolute terms. Two cases are relied upon. Waddington, we can see in paragraph 24, Justice David Richards sets out paragraph 74 and 75 of Waddington. He also refers to paragraphs 12 and 13 of indeed, Fort Gilkicker. One can see that from the last two lines of paragraph 24 itself, just before the extract from Waddington. With that in mind, if I can take the court back in the bundle to Fort Gilkicker itself, which is the previous tab, tab 13. Paragraph 12 is at the bottom of 293. Paragraphs 12 and 13 are part of the judge's recital of the facts. effectively it's an allegation of diversion of business opportunities, so that the court can understand the context of paragraphs 12 and 13. UPMS is the claimant, with an Ian Pearson, who was the second defendant. They were members of an LLP, which was the sole shareholder of Fort Gill Kicker Limited, which is the subject company. And it said, paragraph 12, that Mr. Pearce allowed options to expire and set up a competing company owned and controlled entirely by Mr. Pearce himself. But the point, for present purposes, that 12 and 13 are merely part of the factual recitation. No mention of reflective loss there, certainly not part of the ratio of the judgment. The only references to reflective loss appear at paragraph 16 and 56 of Fort Gill Kicker. The highlighted bit at the last few lines of paragraph 16, reference to Foss and Harbottle. And paragraph 56, top of page 303. This is in the context of alternative claims. And it was argued that there were two alternative claims. One was a claim under the joint venture agreement, and the second was an unfair prejudice claim in relation to the LLP. And the judge was persuaded that either of them was sufficient substance to displace a multiple derivative action. So again, not talking about the question of standing, talking about the alternative claim. And that's where the reference to reflective loss is in there. It doesn't provide any basis for providing a requirement, as is said by Mr. Justice David Richards in paragraph 24 of Aberaya, that all the cases have taken as a requirement the existence of reflective loss. Only two cases have been identified, Waddington and Fort Gill Kicker, neither of which, I say, is authority for the proposition on which the judge relied below, and in fact used as the basis for his conclusion that reflective loss was a necessary requirement of standing. That's the argument, principal argument from precedent. Next point to make briefly is that there are other exceptions to the rule in Foss and Harbottle, namely the failure to follow special procedure, case of Edwards and Halliwell, and also the acting ultra vires, where no requirement of loss is required. But I say that the judge's conclusion below that reflective loss was required is wrong in principle for a number of reasons. First of all, imposing this requirement of loss undermines enforcement of the duties in sections 171 and following the Companies Act, where loss is not a precondition of any breach. They're actionable per se. Requiring reflective loss as a matter of standing imposes an additional hurdle and a disconnect between the underlying substantive statutory duties, which my clients seek to enforce, and the threshold test of permission. Secondly, loss is not required as part of the statutory framework. It's inappropriate to introduce further differences on the one hand between the common law multiple derivative test and the statutory test.
In section 260?
Yes, 260 and following. Thirdly, it's possible that in focusing on loss, one might exclude claims where what is really concerned is the profit which has been obtained by fiduciary, the director, which is what happens in a number of these cases, and that's the real cause of concern. Fourthly, it would have the effect of completely stymieing my submission claims in relation to companies limited by guarantee. for the very reasons we've been debating this morning. USSL does not and cannot distribute profits to members. It doesn't suffer losses which impact on members, i.e. directors' economic interests. And finally, requiring reflective loss as an element or a precondition of standing would make it virtually impossible for members of a pension scheme to ever bring multiple derivative claims on behalf of trustee companies. Even in the case of the industrial asset stripping, to use the language of the judge at paragraph 28, a member of a scheme would only have loss, would only suffer loss in relation to their accrued rights if none of the bodies with a duty to contribute to the scheme was able to make good that loss. And in summary on this point, I say that the judge was, with respect, wrong, both as a matter of precedent and principle, to impose this requirement of reflective loss. As a matter of detail, he rather inverts the concept of reflexivity. Normally one talks about the individual's loss being reflective of the company's. He puts it the other way around, but that's not my primary concern. Primary concern is to say that imposition of an additional threshold as a matter of standing was wrong. My Lord, I'm an hour and 20 minutes behind where I'd anticipated to hope to be at this stage. But if I can deal with the first part of the respondent's notice now, and hopefully briefly. I've advertised this on a couple of occasions this morning already. The first point of the respondent's notice is that an alternative remedy is an absolute bar to the bringing of a derivative claim. The essence of the company's written argument is that the Court of Appeal case of Barrett and Duckett, which we'll come to shortly in the core bundle, is authority for the proposition that common law derivative claims are restricted to cases where there is no adequate alternative remedy. The courts note that's paragraph 52 of my learned friend's skeleton argument. That case, Barrett and Duckett, was cited by USSL before Mr. Justice Leech for a different proposition. The proposition, if I read out from paragraph 14, was, and I quote, "In contrast," this isn't in the bundle, I'm simply reading from my own friend's skeleton last year. "In contrast, a derivative claim is not necessary where, as a matter of law, the cause of action is vested in the prospective derivative claimant, and the claim is being brought to benefit the claimant rather than to benefit the company. Such circumstances fall outside the rationale for derivative claims." Just to be clear, I take no point on the company's raising this argument now on appeal. My only issue is the one of the merits of the claim, of the argument. But it's helpful for the matter to be resolved, and it helps amplify what is the concern of multiple derivative claims. And ultimately, it's a question of wrongdoer control. In essence, the company's argument is as follows. Because the derivative claim is an exceptional remedy, born of necessity, it's not available, but there's an adequate alternative remedy. There's no necessity here because the claimants have a direct breach of trust claim. And while they recognise that recently the case law has treated an alternative claim and alternative remedy as a discretionary factor, they say that historically, in a Court of Appeal level, it's an absolute bar. And I say in response that historically the concept of another adequate remedy was bound up with the concept of wrongdoer control. Derivative claims were not permitted when a winding up petition had been presented and when wrongdoers were not in control, as there was another means of bringing a claim, namely a claim by the liquidator. And one can see that from going to the case of Barrett itself, its core bundle of authorities, tab 10. In this case, the Court of Appeal struck out the claim on two bases: one, alternative remedy, and secondly, lack of good faith. What we're looking for, would it help if I give authority bundle references, the large letters at the bottom? it's page 213.
Yeah.
The highlighted section. The shareholder will be allowed to sue on behalf of the company if he's bringing the action bona fide for the benefit of the company for wrongs to the company for which no other remedy is available. Conversely, the action is brought for an ulterior purpose or another adequate remedy is available. The court will not allow the derivative action to proceed. I'm looking for other section, which I've been working with different. But the position there, that was a case where there was the possibility of a claim brought by liquidators, and the importance of liquidators is apparent from a number of the subsequent cases. First of all, the case of Fargo and Godfrey, which is in the composite authorities bundles. I'm afraid we need to move away from the core bundle.
Well, if we're going to do that, we'll do that at 2 o'clock.
Certainly, I'd apologise about that at the time.
All right.